with that kind of a wild introduction, Joanmarie, you want to tell a little bit about yourself and your firm and your expertise, and then go right into your presentation, and Caitlin will facilitate us. So.
Okay, excellent. So my name is Joanmarie Dowling, and as Pat said, I own my own practice. We represent a fair number of human services organizations. I actually started my career in human services. I worked for one of the ARCs, the one here in Albany, and I also worked for an agency, Camry, which is now part of Living Resources, working mostly residential. But I decided to go to law school and concentrate my practice primarily in employment law, and found that I wound up attracted to the same kinds of organizations I had worked for before I went to law school. So, your type of organizations are really near and dear to my heart. I met my husband actually that way.
That's right. You told me that story. Yeah.
Cool. So I'm really excited to be here. Excited to partner with NYSRA and NYSACRA now too. And right. And so I wanted to talk a little bit about labor law and employment law type issues. A number of years ago, I was speaking to a group of HR professionals from an OPW regulated organization, and one of the things that he said is, look, you talk to HR professionals all the time. We need something that's broader. We need the program people to understand these kinds of issues as well. And so that's, I think, one of the things that we're really looking to do here is to speak to people throughout the organization, program, HR, and all sorts of folks to try to better understand these issues as your business is changing, and as the relationships you have with the individuals you serve are changing. It's important to know what the legal landscape is in this area, because there's a lot of ways that you can get tripped up. So I wanted to start off with worker classification. And when we talk about worker classification, we talk about, is this a regular employee? Is it an independent contractor? Are they volunteers or interns, or what are they? So I wanted to start off with that. We're gonna talk about federal, and then we're gonna talk about state. It's a little bit confusing because we have to deal with both groups, both laws, because the rules are not always the same, and we have to comply with both.
Caitlin, are you advancing her slides, or are we advancing?
I think I'm
oh, there we go.
Maria.
Right.
There you go.
So I wouldn't be any kind of lawyer if I say, look, we're going to be speaking generally. If you have particular questions, please feel free to let us know here if you have a general question, but if you have something more specific that you want to talk about, that maybe you want to talk about in a group, all of whom could testify against you in the court of law, maybe
spoken as a true attorney.
Maybe you email Pat and we can talk offline, or if you have questions for the next program, we're going to try to deal with, talk about as many or respond to as many questions as you might have. So with all of my housekeeping, I'll start off. I wanted to start off with a case study. Her name is Linda because we had a beloved member of our firm who retired yesterday. And so in her honor, she is going to be named. I usually use family names because that always helps to explain so nobody feels hurt. But, because sometimes my hypotheticals, the people don't come out as well as they do in this particular case study. Sometimes they're doing awful things. But at any rate, this one's a good one. She's an OPW Pathways participant. She participates in 2 unpaid work experiences, and you should have a case study. It's a 1-pager and gives you kind of the highlight of the first placement and the second placement. But at any rate, so she's a Pathways participant. She's told her counselor she's interested in clerical work. But she's never had a clerical job, so she would be looking to explore that to see if it works out. And as a part of the Pathways program, her counselor arranges for 2 unpaid work experiences. So, one of the things as we sort of go along, I want you to kind of be seeing from my perspective what the kinds of things that I would look at and how I would analyze it. So we're going to look through these case studies. We'll talk about the first placement and the second one, and then we're going to start to talk about some of the legal rules and how we might apply that to this kind of situation, just to give you a taste of the real-world assessment. As good lawyers, I'm sure that you're going to have questions. There'll be information that we still need to get, but it'll give you a flavor for the kind of analysis that we would go through if we were working with you and determining whether this can be an unpaid internship or unpaid work experience, and what our justification would be for that. So, so the first placement, she's got a 2-week experience at a nonprofit. The first day that she comes in, she spends about 2 hours. She's observing an administrative person who's Xeroxing or copying multiple copies of a newsletter. She's preparing mailing labels. As a part of this, she's also talking to her counselor about her observations, what it's like in terms of dress code, the work hours, the things that, the tasks that she thought she might be interested in doing. And they stay for a couple of hours. So she comes back on the second day. She's a half hour late. She talks to her counselor and explains that she had an issue with her mother that morning that delayed her. And her counselor talks to her about how she can resolve the issue with her mom, and they discuss the importance of attendance and punctuality and those sorts of things and how important it is. This day, when she's there, she's doing more mailing labels on the newsletters. She's stapling them and getting them ready for mailing. The clerk is with her, it's supervising her, helping her, training her as she needs. Okay, so she doesn't work full-time, but she's working maybe a few hours a day and not every day. She, by the end of this though, she's able to copy and staple the newsletter. She does the mailing labels. She's done all of those sorts of things. She continues to need, though, some supervision and some assistance from her counselor in terms of navigating the workplace. But by the second week, she's able to progress to the point where she's able to do these tasks with more limited supervision. So at the end of that first placement, she talks with her supervisor to talk about what she likes, what she didn't like, and to decide what her next work experience might look like. And she really wants to focus on working on the phone. She thinks that might be interesting, a little more engaging perhaps than stapling and mailing things. So she would like to explore the idea of being a receptionist. So her counselor arranges for her to observe a receptionist at a local dental office. It's pretty busy. She observes for about 10 hours the first week, during which time she's trying to memorize the staff and roster and to kind of understand a little bit about how things are working. Ultimately, she's there for 3 weeks, though the second week she's worked her way up to covering the phones while people are on break and lunchtime. Normally, they'd have another staff member who does that, but their supervision, being kind of in close proximity, is enough for them at that point. As the 3-month experience progresses, she gets more and more independent, and she's able to do this on her own. By about the second month, she's working approximately 20 hours per week in the second and third month, and now she's freeing up the receptionist to be able to do other things, to catch up on filing and other kinds of projects. At the end of the work experience, Linda's offered a part-time job as a clerk at the dental office. So those are our 2 hypotheticals, and you can refer back to the case study as we go through to kind of to keep those fresh in your mind. So, so we have a question: Can we make these 2 experiences unpaid? Should they be unpaid? And how would how would the U.S. and New York State Departments of Labor look at this for purposes of, does she have to be paid minimum wage? Does she have to be paid overtime? So the first two that we're going to talk about is the Federal Fair Labor Standards Act and the Internal Revenue Code. And primarily we're going to focus on FLSA today, the Fair Labor Standards Act. We're going to talk briefly about the Internal Revenue Code when it comes to independent contractors. But we're going to talk about some additional tax considerations that a lot of people have struggled with. There's a lot of it sounds like noise in the air about what you can and can't do when it comes to employees and some IRS rulings that have circulated. So we wanted to talk a little bit about those as well, which we'll talk about the next time. So the Federal Fair Labor Standards Act is the federal law that guarantees minimum wage and overtime for employees unless they fall within an exception. So the default always is that an individual, a worker, is an employee, and they are not exempt from minimum wage and overtime, which means that they would have to get paid minimum wage for the hours that they work up to 40, and time and a half or overtime rate for those hours over 40. So that is always the default. When we're not going to pay somebody minimum wage and overtime, or we're not going to pay them at all, we have to find an exception, a bucket in which we can put those people to justify not paying them for that experience or not paying them overtime. And then the Internal Revenue Service, they are primarily, of course, concerned with taxes, as we all know. They are looking for money, as one of my colleagues said. That's why revenue is their middle name. And so, again, the default will always be that they are an employee, and as such, we have to do the regular withholdings and deductions, payroll taxes, and those sorts of things. So we have primarily three buckets that we look at. One is employee, and as I said, that's typically the default. Independent contractor, which gets a lot of attention because it seems like people have a lot of confusion about what an independent contractor is. And then a non-employee and an unpaid work experience. So to start off, when we talk about employee status, as I said, that's the default. You know, it has implications not only for what people need to get paid, but also the tax implications. It also will kind of help inform whether individuals are covered by other types of law, anti-discrimination law, and also safety and those sorts of things. But bear in mind that the rules for one law aren't the same as the others. So they're really kind of looking at different things. So somebody might be an employee for purposes of wage hour law, for how they get paid and what breaks and those sorts of things they get, but may not be an employee for purposes of taxation or for purposes of anti-discrimination laws or other types of laws. Or it may be the reverse. And so it's important to know that, because sometimes we would think that the law is fairly consistent. Individuals either an employee or they're not. But that's not the case, and if it were, probably wouldn't be as busy as I am.
We probably wouldn't be having this seminar.
And maybe we wouldn't be having this seminar. I'd like to think we'd have other work that we could do together.
Sure,
but
there's always room for interpretation. And
absolutely,
that's the key.
Absolutely. So that gives you kind of a flavor of the things that we'll be talking about this session and next week. In terms of all of these things, whenever we're making classifications, we always want to think about what kind of documentation we need to have. Because the documentation that we need if an individual is classified as an independent contractor, for example, is different than an individual who's an employee, which is different from if they are an unpaid worker. So we always want to make sure that as we're doing the assessment, the next questions are, what kind of documentation do we need to have? And finally, consistency in treatment. So sometimes I see individuals who are classified as volunteers, for example, but all of the documentation that they have is employee this and application, and they use the same documents and policies for those individuals. Those are things that make it more challenging if ever you're audited or you have a litigation. We want to be as consistent as we can and make sure that the words that we're using and the way that we speak about individuals, particularly who are independent contractors or unpaid workers, that we're consistent with that status. So we're not talking about people as employees if they're not employees, or calling them independent contractors when they're really not independent contractors. Okay. So who is an employee? Well, an employee is anyone the employer suffers or permits to work. I was doing this a few years ago. My son, who's turning 10 this year in just a week, was younger, and he saw me working on this. He saw me working on a slide very similar to this, and he looked at me quite horrified. And he said, "Mom, do the people who work for you suffer?" And I was, "No, buddy, it's okay. They're not suffering."
Now, there are some people who work places that might suggest that indeed does, is a definition.
Hopefully nobody who's working for me at the firm is feeling that way. Maybe when I go back to the office, I'll ask them. Yeah. And they'll know the right answer, which is, no, we're not suffering, Joanmarie. We love what we do. We love working with you. But so suffer usually means, or suffers or permits means that we allow it to happen or we require it to happen. So in cases where an individual, we know that they're working, even if we didn't direct them to be working, we may still be, we still may be obligated for unemployment, but generally speaking, individuals who are working for us, as I said, are typically considered employees. So what are the requirements? As I said, minimum wage for the first 40 hours, and then time and a half, the regular rate for more than 40 hours, and that's per work week. So if we have somebody who works 50 hours in the first week and 30 hours in the second week, we don't get to average those out. We have to do it per work week. So when we're looking at worker classification, particularly those who are learning or exploring, part of the challenge is to try to figure out what is the purpose and what's the primary what is the primary focus of what we're trying to do. Is it educational exposure? Is it helping them to develop, or is it to make product or to do work for the employer? And a lot of times when we look at this, it may be a bit of both. If you think about our second placement in our case study, for example, the individual, I would say, was primarily there to learn what it was like to be a receptionist and what kind of skills she needed to have, not only to do the job, but to fit into that office environment. But at the same time, she was producing some stuff. Yeah. She was answering telephone calls and directing people to the right place. She was freeing up other staff. So it's always a challenge because usually we have both. We're trying to figure out what's the primary focus of what we're trying to achieve.
Would that go back? I apologize. I have the luxury of being in the room here, guys, so I'm not typing anything in. But yep. Would that go back to, you made a comment earlier about documentation. So in order for the organizations to help themselves see the difference, or if the goal of the individual, especially as you talk about the pathway service, was really definitively saying that it was to be learning and to be focused on learning even through experience or something like that, that would then present the capacity for the argument for learning versus producing, or am I trying to stretch this too far?
No, absolutely. I think having documentation that shows what the goals are of the experience how it fits in with the overall work that you're doing with the individual serving, and how this particular experience, what they're gaining from it, is certainly going to be helpful. And I think that when you're able to do this, and you're going to have to be doing these things anyway, right?
Well, but I would suggest that, and I'm going to look to the colleague that's in the room with me too, as just somebody that's live and that we can react to. A pathway goal, really, I mean, it's defined that way, but I'm not so sure we all in the field take enough time to think about. That's why this is important. This 2-day seminar that you're doing for us, to really look at the other side. We tend to focus on the rehab side, and we think we're responding to everything there, but it may need to go just a little bit deeper to offset the challenges that you're presenting here, is what I'm thinking. Make sense?
Yeah, I actually, unfortunately, I don't think our people in Pathway really understood this, because I have people in Pathway and I wish that they came back.
That's
I'm in HR, so I'm like
that's
here
even, but that's okay, that's good.
Right, so I'm here to learn, but I'm going to go back and say, you know what, our job coaches, our employment, our pathways, this is who should be here.
And I think
because they're working with other employers.
Yeah. I think a good example of the kinds of places where pathways, where staff, job coaches, and other folks could really bolster their documentation to the extent that they're not doing this already, is to talk about the generalness of the experience, the transferability of the skills that they're getting. Because one of the things that auditors, investigators, and the courts are going to look at is this learning how to do a specific job, learning to work at this particular dental office, or is this experience that she could take and transfer other places? And I don't know how well of a job.
Well, and I'd also want to make sure people understand that there's nothing afoot right now in New York that is lending itself to the labor office looking at needing to come out quickly and do audits on all of this. We're on the front end of this wave, and so the more you are on top of presenting and starting to teach and work with your crew and staff on how to properly do this, then there'll be no problem later on. It's not addressing it from the beginning, and so as this issue started to bubble up from all the work we were doing with the transformation of work centers, it was obvious we needed to be on the front end of this wave and not be underneath it crashing later when the labor auditors all caught up to the advocacy that might be going on in Washington from states, Washington D.C. that is, from states that don't do this properly. We want to be on the front end doing it the correct way. So thank you. Yeah.
Absolutely. And I would say also it may help in terms of getting more experiences at for-profits who may be a bit wary, particularly when they can't afford to pay somebody or they're not willing to pay somebody, but wouldn't mind taking the time to do these sorts of things. If you've got the documentation to back it up, that may help sway them to being more more interested in pursuing.
True, and I think more organized too, that it's less, you in your second case study, you talk about someone that's actually on the job several months versus several weeks. So your capacity to truly design an assessment, an experiential thing that gets at the core of what someone wants to investigate gives you all the more credence than when you approach an HR personnel office around this is how we're going to do this. They're on top of their stuff because they have to be, and they'll be that much more engaged in the conversation. So you guys got to really think through how you're going to organize this for your folks.
Well, and when you can speak the lingo, it's going to give you a lot more credibility. That somebody.
So Joanmarie.
Yeah, go ahead.
We actually have a question. I've unmuted Andrea's microphone. Andrea, if you want to go ahead and ask your question, you're all set.
Thank you so much. I have a question regarding implied employment status. I attended a conference and they mentioned it, but they didn't go into too much detail about specific liability. Like they said, like giving interns things like policies or handbooks that reference employees that might imply somebody has an employment status, so you might have employment liability with that person. Are there other things besides policies that might imply employment that we should be aware of? And is there a different liability of written implication versus verbal implication of employment?
Yeah, so we're going to be talking about this, so it's a good segue into some of the material that we're going to be covering later in our session today. But absolutely, when they're talking about implied employment, I think what they're referencing is that issue of consistency in documentation and how you're labeling the worker who's performing some service or who at least is on site. And learning about the kind of work that you're doing. So you want to be consistent with that, and I would say you also want to make sure that you've well documented what the experience is going to look like and everybody's on the same page. As a part of the process that you're doing, you want to be clear about what the expectations are for everybody, make sure everybody's on the same page.
So an intern is an intern is an intern.
Exactly.
Not a worker, a trainee, a potential employee, right?
Well, I think definitely, at least in terms of if you're speaking about unpaid workers, you're using a term, throughout, but definitely not giving them, for example, the employment application. Not giving them a copy of the employee handbook. And being very clear at the onset that people aren't going to get paid for what they're doing, that they're not guaranteed a job at the end. And so if you look when you look at the ground rules, we're going to talk about it in a minute, we'll talk about some of the things that we're going to want to make sure are covered in the documentation, that we're being consistent with it. So absolutely.
Cool. So Joanmarie, can you have an application then for volunteer / intern / work experience? Can that be the same application and then an employment application, or should you have like individual ones?
I'm sorry. So a
category.
Volunteer, intern,
all the unpaid classifications.
Yeah. Can that all be like the same? Can we have like a handbook and an application that fits that group and then employment, or should we have a volunteer application and a volunteer policy, an intern application and an intern policy?
Yeah. I don't think. Yeah, I think what's more important is to have the employee documentation and the non-employee documentation. I don't think it's necessary that you say these people are volunteering versus these people who are having a different kind of work experience. Because the truth of the matter is, you may have people who fall into more than one bucket. So we're going to walk through some of the different ways that individuals can be unpaid in just a minute. So let's start off with independent contractors. We're going to talk about 1099s again a little bit in the next session. But independent contractors is a term that a lot of people use to describe anybody that we are paying, but we are not worrying about minimum wage overtime or any kind of payroll taxes. We pay them straight up whatever we've agreed to pay them, and they're responsible for any taxes. We're not paying any employer taxes, and we give them a 1099 at the end. Independent contractor is one of the ways that you provide a 1099, but there are lots of different ways of providing 1099 income. And when we talk about the individuals that you're serving, typically those individuals are not going to qualify as independent contractors. And even when you look around with other vendors that you're working at, you have to be very careful, especially with smaller, solo practitioners or individuals who are consultants, to make sure that they are properly classified. Independent contractor has been of particular interest, I would say, in the last 10 years or so, particularly under the Obama administration, because the top administrator within the organization was very, very concerned about making sure that people were properly classified. So what do we do in terms of independent contractor? Who is an independent contractor? Well, generally speaking, an independent contractor is somebody who's in business for themselves. So somebody who's operating a consulting business, someone who's operating a law practice, somebody who's operating a business to provide yard services or other sorts of people who are in business for themselves. Typically, the relationship to the business is that they are not performing the same work that the business is performing, but they're supporting the business operations. So if I'm providing services to a particular nonprofit, I'm not actually doing the work that they're doing. I'm helping them to comply with the law. I'm supporting the business itself. I'm not actually engaged in the services that they're doing. In contrast, sometimes you'll have people who, I think that probably the easiest example to think about is individuals who are providing janitorial services. Sometimes a janitorial service will classify all of its workers as independent contractors. Those individuals aren't in the business typically of operating their own janitorial services. They go where that person tells them to go. They are performing the work that the business is, the janitorial service itself is in the business to perform. The individual who is an independent contractor has to have an opportunity for profit or loss. That means that they get paid, and if they are thrifty, or if they adjust their business operations, they may be able to make money, or they may lose money, and that's a risk that they have. That they are investing in the business, so it might be tools or business cards or computers or any sorts of other things, but they are investing in that. That they will look at the skills required for the work. So the more highly skilled the person is, the more likely that they are to be an independent contractor or properly classified independent contractor. So, for example, lawyers often are treated as independent contractors, and properly so. The concern about exploitation of lawyers, nobody's concerned about exploiting the lawyers. They really don't. They don't care how we get paid or any of those sorts of things. So that might be another place where we're looking at. So certainly individuals who are lower skilled, who don't require a lot of training to do the work that they're doing, would be less likely to be independent contractors. They look at how long the relationship is going to last. Is it a very short project? Or have they been an independent contractor working with the individual for 10 years? And may also look at how many other clients they have and those sorts of things. Are they bouncing between a number of different clients, or are they working for one organization and fairly embedded? And then finally, and perhaps most importantly, how is the entity who's getting the services from the purported independent contractor, how much control does that entity have over the work? So I'll give you an example, real life. My mother, who is the very worst because she'll call me when she wants advice and then she'll ignore it, called me because she was working for a school district, and she said that she was an independent contractor. And I said, well, where are you working? And she said, at the school. And I said, well, what do you do? Well, I do this, that, and the other thing. I'm working with students that they provide to me. I said, do you have meetings? Or yeah, I have to go to the faculty meetings every Friday. I have to provide these reports and all sorts of things. So she had a laundry list of different things. And I said, Mom, you're not an independent contractor. You're an employee. You should be getting benefits. You should be doing all of this. This isn't right. And she said, oh yeah, no, that makes sense. I explained the rules and all that kind of stuff. 2 weeks later, she called me and she said, I hired a secretary as an independent contractor. And so when you think about the school district and how they were controlling, the hours that my mom was working, where she was working, what meetings she was going to, who she was serving, all of those things are indicators that they are controlling the work that she's doing, as opposed to saying, here, I want you to work on my website, here are the things that I want, go do it, and come back and present me what you think makes most sense. They'll look at advertising, the cost of what the individual is investing in their business, how they're structured, do they have their own entity, And none of these things will decide it. So sometimes people will say, well, we'll just set everybody up as, you know, as businesses. We'll get them a EIN number, an employee identification number from the IRS, and they will be businesses. But that's not. They will look at the actual facts and circumstances of the case, with what they call the economic reality, what's really happening here. It is helpful to have an independent contractor agreement, but it is not, you know, it's not required. It is a good practice. But just because you have an independent contractor agreement doesn't mean that the person is automatically an independent contractor. And finally, they'll look at the number of independent contractors that a business has. So my case example of the janitorial service, if they have 28 independent contractors and no employees, that's obviously going to be a risk factor. So is independent contractor classification a good alternative to employee status? I mean, it certainly does help in terms of not having to worry about minimum wage and overtime if they're properly classified. It takes the burden off in terms of payroll taxes and withholding requirements. But I would say be very, very careful, particularly with individuals that you're serving. Look very skeptically at whether they are properly classified in that way, because very often the individuals you're serving don't have yet the skills, the kinds of meet the requirements for being in business for themselves. There may be some who can, but just be very careful in terms of doing that, because U.S. and New York State Departments of Labor and IRS and Department of Taxation in New York are all going to be looking at these kinds of issues. They do very much look at these independent contractors, and as I said, their default is going to be it's an employee until we prove otherwise. So, unpaid work experiences. We have this handout that talks about the ground rules, and as well on the back side of it, there's possible classifications or really just legal arguments that we might make. And there's the for-profit business and the not-for-profit business. The rules are a little bit more generous when it comes to nonprofits in terms of being paid or having unpaid work experiences, and federal and state. So whenever we're doing this kind of analysis, we're trying to hit as many different arguments, legal arguments, as we can, so we can say, you know, this applies and this, and hope that one or more of them will justify the unpaid status. So we're going to start off with the federal, which is on the left-hand side. And there are a few different ways that we look at this. The U.S. Department of Labor has a work experience enforcement guidance, as well as there may be individuals who are classified as volunteers, interns, or students. And there's a lot of overlap, which is why we have our ground rules, because typically when we're looking at unpaid work experiences, there are some basics that you need to be able to cover. One is that the experience has to be voluntary. And I'm not talking about the difference between slavery or not. Slavery is illegal, of course, but voluntary meaning that the individual wants to do it. If somebody feels forced or compelled to do it, that wouldn't be considered volunteering.
I have a question for you.
Sure, absolutely.
Let's say that the organization has been able to develop 2 sites that offer a work experience in an area that somebody's interested in. They have a choice of that one or the other sites. Is that voluntarily enough? Is that what you mean by voluntary?
Voluntary, meaning that the individual actually wants to engage and do the work. They're not being forced to do it. So
it's not the choice issue.
So it's not necessarily where they would be doing it, but whether they are freely choosing to do the work or not. Mm-hmm. So it may be that it's not something that they're excited about, but they'd rather do that and at least get some experience than something else. Okay. Most often when we get this kind of voluntary status, it comes up in the context of individuals who feel like they are required to work for free in order to ultimately get a paying gig. it may also present when you have somebody who is an employee but is strongly encouraged to perform volunteer experience.
Because I believe under pathway services, as one of the Medicaid's funded services, there is a requirement, now you're using the word requirement, there is a requirement that individuals have no less than, and help me some guys, I don't know, no less than so many experiences in order for it to count. So I have heard from agencies where the individual honestly has had a good job, just needs a job to keep funding what they have, an apartment, their family, whatever. But if they're going to receive a service that the system is approving, they have to go through a bunch of different things that are just like, no, I just want a job.
Right.
I don't need to go back through this whole experiential thing. Just get me a paying job. So the agencies are kind of being pushed into a place where if they want to use this funding source, they lay out the rules, but the rules don't necessarily fit, I don't think, the way you're talking about voluntary, especially if somebody's honestly saying, I don't want that. I just need a job. Help me find a job. So then the agency has to decide whether they're going to provide a service or not, almost, you know, and they're caught between a rock and a hard place of their mission, yet at the same time wanting to assist someone to get back to the world of work, but they don't get funded to do that. So it's the ongoing challenge, I think, that's presented in this picture is rules, as you were saying before, rules that are set up by somebody that are maybe not really connected to what the labor issues and labor says.
Yeah. Well, it's absolutely a problem. It's one of the reasons why it's so good to have these kinds of conversations, because oftentimes agencies don't talk to one another.
Right.
They're not necessarily considering what would be the implications for somebody else. It just doesn't occur to them. I mean, I would say in terms of voluntary, it may be that we would say, look, they're voluntarily entering into this program where they understand that there will be certain things that they need to do. And I understand in some respects it may be checking boxes because they know what they,
Right.
you know, maybe they have a sense, maybe they have one experience right off the bat and they're like, this is it.
Right.
I really like this and I don't want to do
The
some of
rest.
these other things.
Right.
But I think I would be especially concerned if an individual was being required to have an unpaid work experience in order to prove themselves for a paying job, or if they are performing some other kind of paid work for that organization, but they're having to do work off the clock.
Understood. Thanks.
Yep. So the second piece is, it kind of plays off that first one. The individual, everybody needs to understand, we all need to be on the same page that the individual is not going to be compensated. So no wages, no benefits, no promise of future employment at the onset. That doesn't mean that at a certain point somebody might say, gosh, this person was really working out and we would like them to work with us. That may happen, and that's great because, of course, part of the whole reason for this is to, you know, have people employed with employers who like working with them and the individual likes the work, but it can't be at the onset that is an arrangement. The individual has to understand, the business has to understand, the family has to understand, the agency, that the individual isn't going to get paid, isn't going to get benefits, and there's no promise of a job at the onset. This is a place where that documentation really is very helpful. In fact, I was speaking to somebody after a presentation that we had done with NYSERDA before, where somebody actually brought up the sheet that they use to hit some of these points that everybody signs off with at the onset, which from a labor law perspective would be a really great idea. You cannot displace paid staff with unpaid workers. As a general rule, you can't have people who are filling empty positions. For example, that doesn't mean that they can't provide any kind of benefit to the business. But generally speaking, we're not staffing businesses with unpaid workers so that they can get their job done. So I had a client, for example, who was running a particular program, and they were using workers who were volunteering as a part of their student experience. And we'll talk about students in a little while, but one of the concerns that we had is, I asked the client, well, what would happen to the program if you stopped using these 8 unpaid workers, who are about 2/3 of the people that you have performing services for this program? And he said, we'd have to shut down the program. We couldn't operate if we didn't have these individuals. Those are the kinds of things that the Department of Labor will be looking at. And I've had conversations with them where they have specifically noted their concern about this. The idea being that, first of all, they don't want people to be abused and performing services where they really should be paid. But also recognize that they're looking at employment numbers, and the better the employment numbers look, the better the Departments of Labor look. So they want to make sure that we're not undercutting paid work. Generally speaking, the experience has to benefit the individual more than the organization hosting the experience. So primarily this is for purposes of education or exploration. The individual, it doesn't mean that the organization can't have some benefit, but we really need to be able to weigh that. So for example, when we look at the first placement, so this is where she's working at, Linda's working at the nonprofit, she's working on the newsletter, she's stapling, she's getting them ready to be mailed. Do they get some benefit? A little. I mean, they're getting this work done, but the kind of effort that the clerk who's supervising her in that particular task, the work that that person needs to do means that the organization's not getting a lot of benefit. The more benefit that the organization is getting, the less supervised the individual is, the more likely we're going to have trouble with this particular ground rule. And recognize, as in the case of the second placement, to start off with, Linda needed a lot more hand-holding. Further and further along, she was acting more and more independently. And in those cases, from a labor law perspective, we might say, at a certain point, we have to say, this now is really more of an employee-type work situation as opposed to a properly unpaid experience. And so it's something that you don't necessarily want to decide at the beginning and think you're done and and sort of wash your hands of it, but that you have to continue to monitor to make sure that the individual really is getting the kind of educational or experiential learning that they should be getting from this experience, so that that they are really benefiting from it. Similarly, you want it to be benefiting the employee in terms of them getting broad experience. So if you have an organization that has a homegrown system that the individual is learning, but they can't take those skills and go someplace else because it's really unique to that particular organization, then it's likely not going to be benefiting the individual as much as if they're learning something that they can transfer to other types of employers. And the experience is time limited. And in terms of time limitations, the shorter it is, the better it is going to be in terms of making an argument that it should be unpaid. So in the first placement, we're talking about a couple of weeks. In the second placement, we're talking a lot longer. It's 3 months. Both are still time limited, but we're going to have an easier time establishing that the first experience should be unpaid versus the second.
Now, even if, question to you, even if the second one, several months, but if in this several months that person was working 2 days, part days, that factors into that time stuff that you're talking about. So it could be a 6-month period. I'm reacting to people who are saying, well, I've got people who are cognitively challenged and they might need to have more repetition in order to even pick up on whether or not they can or they like it or whatever. So they're not going to, if they're only scheduled 2 days a week, an hour a day or something like that. They may need 6 months to get to that place.
Right.
That's not what you're talking. You're talking about the actual overall experience and what it does for the person. Again, as long as it's giving them something and not turning something around to the business that they're replacing somebody else with, then that would be the argument for that. Right?
Yeah, and for each one of these criteria, each of these factors, none of them is dispositive. None of them is going to be a deciding factor per se. What we're looking at overall is how do they all fit together. We want to make sure that if somebody is working a longer period of time, that this is still an educational exploration type experience, as opposed to the learning stopped at month 2 and now for the next 4 months they're really just producing.
Right.
Yep.
Cool. Thank you.
So the U.S. Department of Labor has guidance on unpaid work experiences for the community-based rehab programs. The department has said they will not treat individuals with disabilities as employees when they meet certain criteria. One is that the individual spends a limited number of hours in that particular experience, and we'll talk about what that is in a minute. That they are engaged in unpaid work experience at a job or at a business, and it can't be with the agency itself. It has to be community based, and for the purpose of job exploration, assessment, or training.
Okay. Just make a mental note. We're going to go back to what you just said about it can't be with the agency, because I'm, again, reacting to the people that we invited to be part of this conversation are the folks that are seriously considering starting their own separate or unique businesses. And that indeed could be on the same campus as the organization that's providing the other kinds of services.
Mm-hmm.
We need to look. We may
that
need to look
that
at
might
it,
be,
you and I offline.
That might be something that we
actually
circle back with.
Okay.
I think really the intent is integration, which obviously is the intent of what you all are doing now in terms of transition.
So let's make a mental note to talk about that.
If you'll follow up with me on that, we'll talk a little bit more about that next week. So what we are looking for, or what the U.S. Department of Labor is looking for, so we're looking for it too, is an individualized program. So we do want it to be tailored to the particular individual. The organization is not going to find an employment relationship between the worker and the agency or the school that's helping to facilitate this, or the worker and the business, when you can meet all of the criteria. One is obviously that the individual has to have a physical or cognitive disability that affects their ability to get competitive employment at or above minimum wage at this point. So we're looking at where they are now, not where they would be. And secondly, that they need intensive ongoing support to be successful. So in the case of Linda, where she was maybe still struggling with how does she operate within an office setting, how does she manage problem solving in terms of getting to work, dressing appropriately, being able to manage conflict or speak with her colleagues, those sorts of things would all be things that the U.S. Department of Labor would be looking at. The time spent at the business is for one of those purposes: vocational exploration, assessment, or training. It has to be conducted under the general supervision of the rehab organization staff or public school employees if they're students. It can't be that we drop them off and have very little interaction. It doesn't mean that the business won't also be supervising, but has to be this component of having supervision by one of the staff, supportive staff. Ultimately, our goal has to be employment within the community. So that has to be a part of their plan of service. So we really do want to document what the ultimate goal is, as well as why we have that need for exploration or assessment or training at this point, which I'm presuming that you will probably be having to get in terms of documentation generally to support the services so you can bill for them. But you certainly do want to spend a little bit of time thinking about and making clear that you're documenting this within the paperwork that you're already doing, so that we could use that if ever there was a challenge. As I mentioned, the concern is always who's benefiting more, the individual or the business. So we look at, is there immediate advantage to the business? Is the individual really there just producing, or are they having a learning experience? And so one thing that you will want to look at is how much time do they spend at any particular site or at any particular classification, and what are they producing? So are there ways that we can show that the individual's experience is more general, and be prepared to think about and document, if necessary, what detriment the business has. Are they spending staff time to help supervise this person in a way that they wouldn't have to do it? Is there reduced productivity or no productivity? The U.S. Department of Labor a few years ago said that really they're looking for whether there's little or no benefit to the particular business. I don't think we have to go quite that far, but just recognize that that's kind of what they're looking at to see how much benefit is the employer getting. So what are some indicators that they'll look for? I mentioned displacement of employees. So if you have an individual who is replacing somebody who left or filling in an empty spot, or if you have, as I gave in the example, you have a majority of people or a good segment of people who are unpaid workers who are working alongside paid employees, that might be something that we would be looking at. Particularly if you had to hire somebody to do those and perform those tasks if you didn't have the unpaid workers there. How many employee tasks are they performing, and how much of that work are they performing? So obviously what we want them to do is have a real experience, so we want them to be performing tasks that they might as an employee. But to the extent that they get to the point where they're fairly proficient in doing that independently, more than that may be an indication that the business is getting immediate advantage. I mentioned these other two. So just making sure that when we talked about who's supervising the employees, making sure that there is a real presence for the rehab agency, that they are actively engaged with the individual who's performing unpaid work. So U.S. Department of Labor put some restrictions if you want to use this exception, that vocational explorations would be 5 hours per experience. So they may have multiple experiences, as they might with pathways, for example, but but it's 5 hours per experience. For vocational assessment, you have more time, 90 hours per experience, and vocational training, 120 hours per experience. If you get much beyond those, then I would say it's good to assess whether, in fact, an unpaid work experience is still appropriate.
Does apprenticeship fit into vocational training? Or is that a classification?
Apprenticeship is a different classification, because on the both federal and state, there's going to be minimum hours requirement as a part of apprenticeship. That's going to be in the thousands. It's usually, I think, about 2,000.
And also in the student thing right now, the CDOS work experience, the CDOS credential requires 240 hours of work experience, and adding those up doesn't quite get close, but it doesn't get.
So there may be other places where other classifications that we might use for those kinds of programs, but An apprenticeship, for example, is probably not going to be.
No, but I'm even thinking in regards to just general hour limitations, if this is a limitation, but the school system is actually asking for 240 hours.
Right.
They're not sinking.
So it may be that we, so first of all, these are rules of thumb, generally speaking. I think there may be twice the limit might be pushing it a bit too much, but there may be other classifications that we can use. Oh, additionally, for students, there would be some limitations during the school year.
Yeah, sure.
No guarantee of employment, and that's going to be, as I said, pretty standard forever, for all of these. But they do specifically mention it as a part of the criteria you have to meet. And you have to be able to provide that supporting documentation to the U.S. Department of Labor. The wage hour division is the same part of the U.S. Department of Labor that also looks to enforce minimum wage and overtime. So you want to make sure that you're not referring to people as employees or those sorts of things. Investigators, some may be very experienced, more junior people may get thrown off. We want to have as few questions as possible, and so we want to have consistency. We want to be able to make sure that we can show that the individual is appropriate, that we've met those seven factors. So when we're putting together a plan to try to hit these goals, one of the things that we really want to make sure is that the unpaid work experience, we specifically connected up with their goals and objectives, which really probably should be happening anyway, but sometimes people may just gloss over that. We want to make sure that we're talking about why we picked this particular work site, what's the intent, what's the purpose. And even as I'm looking at this, I said employer site selection. I think we'd probably change that to say work site selection. So we're consistent with our documentation. I'll change that for next time.
Okay.
Duties and how they further the goals and objectives. So why are they doing what they're doing, and what is it supposed to achieve, and how many hours we're spending at a particular site, and assessing, where are we falling within the spectrum.
That's an interesting thing that you just caught it yourself, and I would propose to everybody that's listening too that we, in the rehab field, we tend to, I try very hard at times to change my vernacular to talk about businesses and work opportunities versus quite often many of us will talk about we have a relationship with employers.
Right.
So when we're looking at this theme right now, that works against us to be calling them employers when you really only want an unpaid work experience. So don't let that get lost in this conversation here, is that there has to be, in essence, what I'm feeling is there has to be phases of what you're offering to people. And so they are businesses, and businesses offer different opportunities. Some of them may be unpaid work experiences, and for those that are ready, they're paid work experiences, which then lead them to an employee-employer relationship. To just call them employers, and the system is guilty of that across the board.
Absolutely.
We need to take a lead in changing the way we talk about that. Otherwise, you're even setting yourselves up. So.
Yeah.
Good catch on that one, and I think it lends itself to that statement there.
Hey, Pat.
Yes.
And Joanmarie, sorry. Katrina Stanton has a question, and I've unmuted her microphone. Go ahead, Katrina.
So I have a question regarding when it comes to who's on someone's payroll. With Access VR, we have the community-based work experience where individuals are on our agency payroll but are working for a business in the community. Is there any concern that if that business in the community had a DOL audit, that individual is being paid by us and not the business? And I don't know if my question's clear.
No, it's perfectly clear. I know exactly what you're talking about.
That's why she's cool. That's why she's good at that.
Because some of the organizations that I've worked with have had that same kind of question. And we haven't talked about it today, but maybe actually we do want to talk about it in the next session.
Okay,
I'll put a little
I know
note
that. Yeah, I get it.
is joint employer responsibility.
Okay.
So we tend to think of people as having one employer, but in fact, actually, employees can have more than one at one time. And in that case, when you have joint employer, we're looking at the individual getting paid once. So for purposes of an audit, assuming that you had somebody, an investigator who was savvy enough to pick up on it, the ability to demonstrate that the individual has been paid by the agency is probably going to satisfy U.S. or New York State Departments of Labor. It does create other questions that are really very sophisticated questions about what is the basis for putting somebody on a payroll. I can't just put anybody on the payroll. They actually have to be an employee. So, for example, I couldn't put my sister on my payroll so I could provide her benefits under my plans. And so when you have those sorts of things, you know, there are some questions sometimes about those kinds of issues. I would expect that in the situation that you're talking about, some of it is to facilitate payment if you've got resources to pay individuals, but the work site doesn't. And there may be some other issues, but in terms of straight up wage hour, minimum wage and overtime, being paid by one organization is gonna suffice as long as it's for that particular service.
Thank you.
Good question.
So I'm at 11:10. Okay. So let's walk through some of the rest of this. Just remember that businesses can always pay individuals as employees. So we're talking a lot about unpaid, but you know we can always move people into paid status for the work that they're performing. Sometimes we talk about volunteers and individuals volunteering. Under federal law and under state law, an individual can't volunteer for a for-profit entity. And they can't volunteer to perform commercial activities even if it is for a nonprofit. So off the bat, so if they are recycling cans and bottles and producing income from that, janitorial services would be commercial activities. Those are two that I know people do that just kind of pop into my head. Boxing up or producing hand soaps or
so unless something was determined to be a fundraiser, a one-time happens in the moment kind of thing, then that's okay. But if it was an ongoing relationship of recycling or janitorial cleaning, landscaping, that kind of stuff, of doing garden beds as volunteering, if that was an ongoing thing, then that needs to be questioned.
Right.
Okay.
Then for unpaid work experiences, you're not going to be able to use volunteer.
Gotcha.
And remember, we're just trying to look at different buckets. So just because you don't meet the volunteer status doesn't mean that you can't be unpaid.
Right.
So our ground rules apply. It has to be voluntary. It has to be no promise of a job, etc. There are specific rules with employees. So if you have somebody who's an employee, they can volunteer for the organization, but they can't volunteer to do what other employees would be doing. They can't volunteer to do what they are already doing as an employee. So sometimes you have volunteers, they might work at a fundraiser and might volunteer for that. And in those cases, it may be okay, but they can't volunteer to do what they're already doing. For federal law, an individual has to volunteer for public service, religious, or humanitarian objectives. When you look at our work experience table, you could probably just go ahead and cross off volunteer for federal. It's not even on here because almost never do we have individuals who are doing work service and fall into this public service, religious, or humanitarian objective. They're looking at it to understand where they would like to be to develop competencies that will help them get a job, and that doesn't fall in any of those categories. So when we talk about volunteers, individuals we're talking about are not going to be federal volunteers likely. And certainly can't be used in for-profit situations. Okay, students. So for students, you can have an individual, a student, as a non-employee if you meet our ground rules and there's a structured learning requirement. An individual is receiving ongoing instruction, close supervision at the work site through this learning experience. So it really has to be a part of a much larger plan, and individuals have to be learning along the way. So we're looking at individuals who are learning one activity and then they learn a new activity that builds on that one. So they're getting increasingly more sophisticated. That exposes them to the industry itself as opposed to a very small component. They're learning to see how all of this fits together. They have skills that they can use in other places. It's not just specific to that particular employer, and that they have to be creating. They have to have tasks or assignments that push the individual to be thinking more critically, to learn how to problem solve. So we think sometimes of students, getting coffee for people or running out and getting the donuts or that kind of thing. That is not going to satisfy the federal, and spoiler alert, it's not going to satisfy the state either. So a federal option can be a nonprofit or for-profit. Typically, when we see the student exemption, well, it's not required that they be in school, that there's a real strong learning component as a part of what they're doing. There are different rules for New York State, and it's not tomorrow's session, it's next week's session, but we'll talk a little bit more about that, or maybe if we have time today, we can talk a little bit about that too. Generally speaking, when we're talking about students, we talk about internships, and the rules are fairly similar. U.S. Department of Labor has a 6-factor test that really is looking at the educational benefit of the intern. The Second Circuit is the federal court that is the appeals court that governs several states, including ours. So this is the rule that would apply to us, which is a more employer-friendly test. It's called the primary beneficiary test. And what we're really looking at is what is the intern actually receiving in return for work, and what's the economic reality of this? Is the individual getting work experience that will be helpful and beneficial to the intern in terms of promoting their own skills and their own employability in the future? And they said, look, internship rules are different because interns are getting this educational and vocational benefit that normal staff, other staff are not. That's the for-profit rule. The exceptions for charitable organizations is broader. U.S. Department of Labor informally has said unpaid internships are fine as long as the individual clearly understands that there's no compensation at the onset or throughout. The Second Circuit hasn't really discussed this. They try not to make decisions unless they have to. But I would say trying to develop programs or experiences that meet the for-profit standard, the educational benefit, is always a smart idea. Because ultimately that's really what the internship is supposed to be all about anyway, and it puts you in a better position if the court comes out differently than what we would expect, or the U.S. Department of Labor changes its mind. It's informal guidance, it's not binding on them, and so as much as we can, we want to bolster the argument that it is in fact for the benefit of the intern primarily. And so if we can meet the for-profit test, then we're pretty sure we can meet the nonprofit test. So if we're going to have a for-profit experience, we especially want to make sure that we have educational type experiences as a part of that. If you have groups of people, sometimes they'll have lunch and learn or other kinds of programs where they expose people to different aspects of employment or learning more about the industry in which they're working. If there is an educational component to it, if they are working at a school that we're tying it into their education, if they are not, that we have other kinds of educational components we build in. We really want knowledgeable, experienced supervisors, so we don't want an individual who is working as an intern reporting to the most junior person within the organization if we can. And obviously some of that will depend on the kind of work that the individual is actually performing. So it may be that the individual is knowledgeable and experienced in the work that they're doing, even though they're fairly low level. But if it's appropriate for what the individual is supposed to be getting out of the experience, then that's really what we're looking at. And as we've said before, language consistency. If we're talking about interns, that we're calling them interns, we're not going through the same kind of process that we would for applicants. So when we're, for example, when we're advertising this opportunity, or when we're speaking to, to work sites, making sure that the process of being an unpaid worker or becoming an unpaid worker isn't the same as what we would have for employees. That we're not advertising for interns, we're not responding to people who are advertising for interns, if really what they're just looking for is unpaid help. That's not what this is supposed to be about. So how are we on time?
20 after, yeah, 10 minutes.
Okay. Well, let's talk about next steps, and we'll save the state considerations for next time. Essentially, when we're looking at a particular program, we're going to want to do it individually, and it may even be experience by experience or individual by individual. Ultimately, we can't make a blanket rule, although we can have a fairly good sense if we're following the same processes where a particular experience will fall. But we have to make sure that we're assessing, and for each of the exceptions. So it may be that we think that it will meet the U.S. Department of Labor community-based rehab program exception, and that the individual would qualify as an intern, but maybe not a student and not a volunteer. For other organizations or other kinds of experiences, it may be different. And that we look at the for-profits a little bit more stringently even than we would the nonprofits, specifically the charitable nonprofits, because we know that people would be paying more attention. And I'll tell you, working with a lot of for-profit organizations who've been on the other side of this transaction, they are much more likely to, to offer an unpaid work experience if they feel like you've thought through this process, that you have something that is going to fall within one of the exceptions. Bearing in mind that ultimately they have to make the decision because we can't provide legal advice to another organization. So we can't tell them it's okay to offer this as an unpaid work experience, but we can say, look, we've looked at this, we think it meets the test. We would encourage you to take a look at it and see what you think. But certainly well-run for-profits are going to be more open if they feel like you've hit the buckets and check the the criteria for these various unpaid work experience situations. And ultimately, having proper documentation is really important. It should be contemporaneous, so you should be creating this documentation before the work experience, and that you continue to document through the experience and continue to reassess. You especially want to consider, if you don't already, having a specific notice to the individual, to family, to guardians, whoever is responsible, as well as the employer, that we all agree that compensation isn't going to be provided. We're all agreeing at the onset that there's no guarantee of a job, and so we can show that that was in place and everybody was aware at the onset. So, as a part of the work that you're doing, a lot of it is really just going to be doing what you're already doing, which is showing that the experience is for the benefit of the individual, that it's tailored to their service plan, that to the extent that there is evidence or information that we can document about what the employer, I said employer, say, now that Pat's here looking at me, I'm going to be especially careful. When we're looking at the work site,
You started it.
I know you started it, but she's going to hold me to my standard.
Well, doesn't it make sense? I mean, right? Because it's going to be that much better for these guys to be using that terminology.
Absolutely.
Right?
So if we can look at documenting what's the work site actually contributing to this? What time are they spending in terms of helping this individual? What slowdown in their operations might they have? Those kinds of things are useful too. You know, and I wouldn't necessarily say to the work site, hey, we need to know, you know, how bad this is, right? How much this is, but you know, if we know what they're doing to contribute to this in terms of staff time, that's useful to be able to document as well. If you don't have an unpaid exemption that applies, you know, certainly there's the 14C option for sub-minimum wage, or, you know, as I said, there's always a possibility of paying minimum wage, and there's, even if an unpaid exemption might apply. When in doubt, I would say paying is always the safer option. So do consider, and especially if something's on the line, it's worth running by a labor attorney at the onset.
I will share with you one of the things that came up during a conversation I had with an agency just this week was the concept of they're concerned about the 14C related to transformation and as they build their new companies. But at the same time, they're also realizing that the individuals that are seeking work are have benefits, that would be a risk that they're not willing to lose. So we talked about the ability to actually create hourly positions with, you know, a limit. So maybe we could also, if that's not on the agenda for next time, I can talk to you a little bit more about how to help these agencies, you know, because there is a classification of just being an hourly worker, right? And you work to a certain number of hours, and then benefits is not something that would potentially get into the mix if many of the work center, the folks that are participating in work center activities are not working even close to 20 hours a week. They just barely get there. And so I think that's a threshold for a benefits question. So you could get to, if you had a contract that would support it, the ability to let someone be an hourly worker at minimum wage, meet the expectations of what's being pushed by OPWD around integration and inclusion and the settings rule, but not feel like your organization was now going to have to take a major hit in coming up with a benefit packet for that workers. Right. Again, though, in that vein, is it not true that each classification of employee can have a different set of benefits offered to them depending on the work that they're doing?
It depends on what benefit you're talking about and what threshold you're talking about.
So again, we can talk offline, and maybe we have a third session for you, girl.
Yeah, right. Absolutely.
Okay, cool.
But it is important to consider those benefits, and again, to look at them, you know, each, you know, individually, because different rules apply, whether it's retirement versus welfare.
Exactly, that's what I thought. Retirement is the tricky one, because no matter whether you're a part-time employee, once you reach a threshold of working a certain number of hours, you're entitled no matter what. So
yeah, and you have to worry about non-discrimination testing. So discriminating against lower wage employees in favor of higher wage. So there are lots of different rules that
So you
apply.
may have a third one.
Absolutely.
Add in the paid FMLA.
Yes, that's the new
Yes.
stuff that's coming.
We're gonna
So
hit on
workers'
paid-
comp and
yes.
all that.
We're going to talk about paid FMLA a little bit next time,
Okay.
since the Workers' Comp Board very kindly put out the final regulations this week. So, and as I said, anytime you feel like you're not sure where something falls, it's really important to talk with employment counsel early, because if you have a violation and it will affect more than one person, then you have a 6-year statute of limitations, so that if there's an audit or a claim, we'd go back 6 years to see what's owed, and then multiply that by 2, because there's a special thing called liquidated damages, which means we want to compensate for people for the wages that they should have gotten 6 years ago but didn't. So they, as a punishment, essentially, they multiply it. So if you were going to owe $50,000, if you're found responsible, then you actually have to pay $100,000, and attorney's fees for the other side, not to mention your own attorney's fees. So little things can really add up, and when you're not paying somebody, that's even more. So if you're on the line, do think about consulting with counsel. So next time we're going to talk about some of the state rules. We're going to touch on anti-discrimination rules, just so that people are aware. In particular, the IRS rules on payroll taxes and some of the opinion letters or determination letters that have been floating around. And I think we're going to have some
Odds and ends.
odds and ends.